I'm Joe Manning. I'm a private attorney representing homeowners.
You've seen it a few times. You've filed some lawsuits
Many times, over 100 lawsuits.
under this Homeowners Bill of Rights.
Probably 50 under the Homeowners
Okay.
Bill of Rights. I've been doing this prior to the enaction of the Homeowners Bill of Rights. In my experience, what I see happening in the trenches is, the ladies here that have discussed these matters, my experience is consistent with their experience of what I see, what I hear from homeowners that are distressed. And in fact, I've worked with Ms. Pinto's office. They send HUD counselors to some of our mediations or our mandatory settlement conferences, typically at the request of the ADR departments or the judges that are ordering the mandatory settlement conferences. And they're extremely knowledgeable and extremely helpful. And often, I love having them there because then they can, sometimes as the advocate for the homeowner, the other side may not take my word for something, but when the HUD counselor is there and is not necessarily in any particular person's corner, but guiding the neutral, the mediator, or pro tem handling the mandatory settlement conference, they have greater credibility. And frequently they're educating the bank's attorney and the bank's underwriter that's present at the conference about what's possible and how things work, which is certainly distressing after we've been going through months of evaluating and underwriting. With respect to the effect of Homeowners Bill of Rights on the actions that we've filed, I think it's a huge improvement in terms of providing tools to private attorneys to assist homeowners in trying to save their homes or prevent foreclosure. Foreclosure prevention doesn't always take the form of saving the home. It's a complex issue, and there's a lot of data that comes to bear, and there are many players: the servicer, frankly, the client, the servicer, the judge, opposing counsel, the underwriter, and then the beneficial owner of the loan. And in many cases, when we get outside of the Homeowners Bill of Rights, the National Mortgage Settlement, we've got beneficial owners of the loan that are securitized trusts that then delegate that authority to enact loss mitigation procedures to the servicer. And distressingly, many times the servicer seems to be unaware even of what their actual role is in terms of acting on behalf of the beneficial owner of the loan. So part of what we do in the litigation process, as we try to settle the case, we try to educate them about what's possible. For example, I've had many cases where I've been told that loans had been securitized and therefore nothing was possible in terms of loss mitigation. I've then gone and pulled the publicly reported information on these loans because they're an investment owned by someone. Those people that own those investments track them, and you can get loan level performance frequently. And we can show that maybe 20% of the loan pool has actually been modified, but we've been hearing that it was impossible to modify. And those are just cases where there's a knowledge gap and where the servicer is not aware of the characteristics of the trust. In the scope of Homeowners Bill of Rights, some of the questions I was asked or thought that I'd address, the people that come to me, almost everybody that comes to me has tried to modify their loan and save their home multiple times and failed. I see almost no one that has not tried, and many of them with the assistance of legal aid, some sent to us by legal aid we represent a form of escalation. With respect to Homeowners Bill of Rights, I do see a perception problem on dual tracking. There's a misunderstanding about what that means. What is dual tracking? And some of the other speakers have commented on that. Conceptually, dual tracking can be different. What you think of dual tracking being is often different than what the statute says. And so there's sometimes a misperception by homeowners. They may believe that they're not in danger of foreclosure because they have submitted an application. And that gets you back to the complete application problem And if the bank perceives that the application's not complete, then it's not complete, and that could be a problem. I've had a number of homeowners come to me after the trustee sale of their home, believing that they had a complete application that had been submitted, and therefore they hadn't been concerned, or at least they were concerned, but they hadn't taken action prior to the trustee sale. With respect to cases filed before and after foreclosure, probably 90%, 80 to 90% of the cases I file are pre-foreclosure, and that's because common sense would tell you that people are fighting for their home, and their highest level of urgency is, usually shortly before foreclosure. After foreclosure, people give up frequently. It's difficult to rescind a trustee sale. Homeowners Bill of Rights did something very important, which was it extended the private right of action after the auction up to the time when the trustee's deed upon sale was actually recorded. And I've rescinded several sales. I've been able to go into court, get a temporary restraining order, rescind a sale, and enter into some arrangement that enabled the homeowner to keep their home permanently as a direct result of that provision of the Homeowners Bill of Rights. That's tough because if the homeowner doesn't come to you immediately, the trustee issues the trustee's deed, it gets recorded, and
How much time elapses?
it can be anywhere from the day after but usually, especially with a large servicer and a trustee, it's going to be 10 days to 2 weeks.
That long?
I recently had a scenario where we filed suit immediately after the trustee's sale, and the servicer, apparently understanding the law, which is, I usually don't see them this nimble, issued the trustee's deed that day, and the purchaser ran down and recorded it that day, and before we could even get into court. So that happens. That's unusual, and it's unusual for anything to happen very quickly with the large banks, right? So that was a smaller trustee, but that has provided an opening, at least, for a completed trustee sale to be rescinded under the law. The servicing transfer issue is a major issue. I'm seeing the same thing that the housing counselors are seeing. Frequently, it does mean you start over, or if you're in litigation with the servicer, they'll then say, "Hey, the case is now moot because we're out. These new guys are in, and you basically have to start over." And so we're looking at, seeking to hold the beneficiary, the principal to that agent responsible rather than just going after the agent. But it does present all these things present hurdles for homeowners that are not capable of, financing expensive litigation, and it just becomes a game where you can be worn out. Sometimes I get questions from judges about why is it that we're coming in on an expedited or ex parte basis to seek a temporary restraining order, and it's because homeowners don't want to spend their money on attorneys, and they hope that they can resolve their situation without an attorney. And it's only when it's usually only when they start to lose hope that they actually hire an attorney.
Well, hold that thought there, because we heard testimony of folks getting ripped off, I guess. They're going to the wrong attorneys, it sounds like. But who generally, private right of action, is this? You take these cases on a contingency or fees, or how do you end up, who hires you, and how do you get compensated?
Right. They're not contingency cases. The cases are, we charge either a flat fee or an hourly fee at the election of the client. And it is costly. On the other hand, in most cases, the clients that I'm dealing with are people with some means. They're usually, and that's important, because in order to save
So the
their
folks
home,
here that would be going to legal aid wouldn't be coming to you Typically.
In some cases, they go to legal aid. They get some information. They find out they don't qualify. But particularly in Orange County, you're looking at, home prices anywhere from 500,000 up to 8 million, in my case. And you've got, in some cases, income. People that have a high income and a home that's valuable still want to save their home. And
8
actually,
million, huh?
I think that was the most. Yeah.
Not my district.
Right. That was exceptional and unusual, and that was more of a paperwork issue in terms of the chain of assignments and the legal right to foreclose, and not a Homeowners Bill of Rights.
Do you ever get
case.
courts to award your attorney's fees?
I haven't yet. I've received many temporary restraining orders. There will be cases where we'll seek those at the conclusion of the case, but the cases generally take long enough that we're not there yet. It's a relatively new law. Some of the things that mitigate against that is the banks recognize when they've got a loser and they want to settle the case, and so then they can generally settle the case.
When you say they've got a loser, they want to settle the case.
And so they'll offer the homeowner.
Yeah, but what makes the case, I guess, for bank a loser case? I mean, is it that they recognize that maybe the process?
Yeah, they're dual tracking. I mean, it's clear. I had a case where the bank didn't actually even have the right to foreclose. It was a Washington Mutual loan that had been securitized before Chase acquired it. Chase was foreclosing, but didn't realize that it didn't even own the loan. So it could be something like that, or we also have scenarios where we've got a change in circumstances, and that's recognized by the law, where a borrower has a material change in circumstances, and that's happening. That's an important part of the law, because a couple things. One, property values have increased, so people that were severely distressed, in terms of the information we saw, the analytics regarding how far underwater an individual is, some of them are less underwater, or maybe even just kind of poking their head into the equity territory. Now they become more interested in saving their home. Also, although
But you were saying earlier over here that would change the net present value
That's correct.
test.
that
So
creates a
that would
hurdle.
motivate, I guess, sounds like the bank would be more motivated to foreclose, or
Well, if the
I don't want to put words in your
it's
mouth.
not so much motivated as when they run the analysis, the net
They're
present.
not qualified.
It's just pass or fail, and if it doesn't pass the test, they don't modify.
Okay,
because
I want to be clear of that. It's not a motivation, it's the test of whether you qualify for the modification is changed.
The element is what the net present value test does for lenders is determine whether or not it's more economical to foreclose or modify. That's the analysis.
Sure.
It's all automated. I mean, they just plug in numbers and it works.
Right, and so that creates a headwind for the modification, because now that the property's worth more, the likelihood that the bank will recoup more of its loss in a foreclosure increases, which means that the economics of modification are not as good for the bank. But you have to run the analysis in every case, and it's not
Sure.
always the determining factor. There's an FDIC net present value spreadsheet that's available publicly, and then there are HAMP net present values tests, and each servicer has customized those with the approval of the Treasury to meet its own requirements. There's not full transparency there. Frankly, a lot of time we see the wrong values used, the wrong income used. That becomes another point of contention in these cases. But getting back to the change in circumstances, so one thing that motivates homeowners to want to save their home is they see that maybe their second was forgiven under the national mortgage settlement. Now the property value comes up somewhat. The perception was for a time that it was going to zero, the sort of the mass perception, and all of us saw that or witnessed that. So now it's coming back. Also, employment, although not returning to pre-recession levels, it's better. So maybe a spouse that was laid off has a job, not earning as much, but more. So they're candidates now. They want to save their home, and there's a possibility they can save their home. So even though they've been previously rejected, they'll let the lender know, hey, here's my situation. If their situation's changed in a material way, they're supposed to be re-reviewed. And we've sought, in many cases, we've been forced to seek a temporary restraining order to have the court order the servicer to reconsider them. And in a number of those cases, they've ultimately been able to keep their home. So that's a common fact pattern that I see today. And I also see that there is a strong correlation, economics and so forth aside. Homeowners that fight to keep their homes are much more likely to keep their homes. I've seen people really fight for a long period of time with the help of legal aid, people like myself, Mr. Howard, and there really is a correlation between that, engaging in that fight, not when it's pointless, but where there's hope, and then actually keeping your home.